get the seat with the...
Good morning, Council, ladies and gentlemen. This is the time set for the in-bank hearing. Gorgach versus Reno. We'll hear from the appellant.
Good morning. May it please the Court. I am Patricia Maher, appearing for the appellants, the Attorney General, the Commissioner of the Immigration and Naturalization Service, and the Immigration and Naturalization Service. In 1990, Congress enacted a fundamental change to the law of naturalization by transferring to the Attorney General the authority to naturalize persons from the courts where it had long resided. Congress enacted what is now Section 310 of the INA, giving the sole authority to naturalize to the Attorney General. At the same time, Congress amended the part of the Act that pertains to revocation of naturalization, Section 340 of the Act. Congress left intact the provision at Section 340A, which provides a plenary proceeding for revocation of an order of naturalization through an action in federal court, but Congress amended Section 340H of the Act, which was formerly Section 340I, by eliminating the references to court procedures and making it applicable to actions by the Attorney General. So that now Section 340H, which had been recognized as a provision authorizing a summary revocation procedure by courts when courts entered orders of naturalization, now provides nothing contained in this section shall be regarded as limiting, denying, or restricting the power of the Attorney General to correct, reopen, alter, modify, or vacate an order naturalizing the person. Subsequent to these changes in the statute, the Attorney General delegated her authority to naturalize to the INS, which in turn promulgated regulations authorizing the INS to institute administrative proceedings to revoke an order of naturalization that had been procured illegally or through fraud or misrepresentation to the INS. Those regulations, which appear at 8 CFR Section 340.1, are the subject of the complaint that was filed by the plaintiff class in this action. The plaintiff class has challenged not only the specific regulations authorizing administrative denaturalization proceedings, but also the authority of the Attorney General to revoke an order of naturalization. The plaintiff class sought a preliminary injunction enjoining the INS from proceeding administratively to revoke an order of naturalization, and the district court, finding that there was a serious question as to the existence of authority by the Attorney General to revoke an order of naturalization, and that the balance of harm tipped in favor of the plaintiffs, entered a preliminary injunction enjoining proceedings by the INS under the regulations that are at issue in this case. A panel of this court gave plenary consideration to the legal issue as to whether or not the Attorney General has the legal authority to revoke an order of naturalization, based on the representation of both sides that no further factual development would be necessary for the court to consider that legal issue. The panel concluded that the Attorney General does have the authority, the implicit, inherent authority that was conveyed by Congress when Congress gave the Attorney General the authority to naturalize. The panel determined that she also now has the authority to revoke an order of naturalization. Now, the plaintiff class contends that if this court were to order, as the panel did, that the Attorney General has the authority to revoke an order of naturalization, that it would be unprecedented for the INS to conduct administrative proceedings to revoke orders of naturalization. Now, that is true in one sense, that prior to 1990, only courts could either enter an order of naturalization or revoke an order of naturalization. But to say that it is unprecedented for an agency to have the authority to reopen, reconsider, and vacate an order that has been entered pursuant to the authority that it concededly has is not unprecedented. In fact, it has been widely held that administrative agencies have the authority to reopen and reconsider their own decisions, particularly where the statute contains no express prohibition.
Is there any time limitation on that? Would that be also true in a situation where 5 years later there is a revocation that takes place?
Well, Your Honor, I think the case law holds that orders can be reopened by agencies within a reasonable period of time, and that's something that is not defined in the case law, and I think what is reasonable may vary according to various agencies. Here, the regulations that were promulgated by the INS authorize reopening within 2 years after the entry of the order of naturalization. Under the prior procedure, when courts entered orders of naturalization, the summary proceeding under section, which was then section 340I, authorized reopening within 1 year because that is the applicable time period under the Federal Rules of Civil Procedure, Rule 60B, for reopening. So there is no particular time as long as it is a reasonable period of time. However, under Section 340A of the INA, which provides for a plenary proceeding to revoke an order of naturalization, there is no statute of limitations. An order of naturalization that has been obtained, illegally obtained, or procured by fraud or misrepresentation can be vacated by a plenary proceeding in a federal court that's brought at any time.
Counsel, you've used the word plenary proceeding as though to imply some statutory distinction between plenary proceedings and some other kind of proceeding. Here's what I found in the statutes, and I want you to educate me if I'm missing something. You have a statute on revocation of naturalization that says it's the duty of United States attorneys to institute proceedings in any district court for the purpose of revoking and setting aside the order admitting such person to citizenship. You have a statute that says nothing contained in this section limits, denies, or restricts the power of the Attorney General to correct, reopen, alter, modify, or vacate a naturalization order. And you have a statute that changes where naturalizations are done from district court to the INS. I don't see a statute that says this is what a plenary proceeding to denaturalize somebody is, and this is what a non-plenary proceeding is, and you do the non-plenary proceedings in the INS. Am I missing something?
Well, Your Honor, there is no statute that further specifies what the plenary proceeding is.
Did you make up the word, or is the word used in the statutes?
It's used in the case law, and it was used in distinguishing at the argument before the panel, the procedure under 340A, which is an action filed in federal court, a federal case brought by the U.S. Attorney to vacate an order of naturalization.
So you're conceding it's not in the statute?
It's not in the statute. The term is not in the statute.
You drew your inference, a saving clause that says nothing contained limits the power of the Attorney General. It may imply by a negative pregnant that the Attorney General has some power, but it does not expressly give the Attorney General any power. The express grant of power is to naturalize citizens. Is that right?
That's correct. Section 310 is the grant to the Attorney General to enter orders to naturalize.
To naturalize.
That's correct.
Now, what I understood to be the heart of your argument didn't make sense to me. The heart of your argument seemed to be that the power to denaturalize is inherent in the power to naturalize. An analogy that comes to mind today is most state legislatures give the power to marry people to ministers. The ministers may have some very limited authority to not sign the certificate after they say, I now pronounce you husband and wife. I don't know exactly what limits there are on them. But most assuredly, even though the state legislature does not give ministers does give ministers the power to marry, it does not give them the power to grant divorces. That power stays in court. Since you have a statute here that says U.S. attorneys are supposed to denaturalize in court, I wonder why we shouldn't just draw an analogy to legislation that gives ministers the power to marry but not grant divorces. Here, the legislature gives the INS the power to naturalize but not denaturalize.
I agree with Your Honor that the INA specifically gives the Attorney General in express terms the power to naturalize. I'm not familiar with the statutes giving ministers authority to marry, and I don't know if there is a restriction in those statutes that says, but they may not undo marriages. And in the INA, there is no prohibition on the Attorney General to vacate or reopen, reconsider an order of naturalization.
The President has the power to pardon. Can he revoke a pardon?
I don't know, Your Honor.
Well, the point I think Judge Kleinfeld makes, which I think is a powerful one, is that granting authority in some instances, particularly when there's a dramatic difference between the one act and the other, can be very different. The right to the power of the authority to marry is very different from the authority to grant a divorce, just as granting a pardon is very different from revoking a pardon.
Your Honor, I think it is not unusual. Well, first of all, when the courts had the authority to enter orders of naturalization, there was no express provision in the INA that said courts may also revoke, vacate, reconsider orders of naturalization. But I think it is widely held that in administrative law, that agencies that enter orders are typically the ones who have the first opportunity to reopen and reconsider those orders, particularly when there is a showing that they have been fraudulent, obtained based on fraud or misrepresentation, rather than a party going to the federal court in the first instance with evidence of fraud or misrepresentation. It is typical to go back to the administrative agency to give the agency an opportunity not only to reopen and correct, but preserve the integrity of the proceedings before the agency.
Counsel, may I ask a question to follow up with that? The statute that we're interpreting here was passed in 1990, and this case was filed in 1998 in the district court, I believe. And I wondered whether the record has any history in it of how the statute has been administered by the Attorney General in the intervening years between 1990 and 1998.
Do you mean in terms of the revocation of orders of naturalization? Well, the regulations that are at issue were first published, I believe, in 1994, but were not finally issued until 1996. And there were notices of intent to revoke that were issued. So there were the initial attempts were made by the INS to begin the process of administrative revocation of naturalization orders, but that has all been enjoined as a result of the preliminary injunction that was entered in this case, and nothing further is going forward. The only revocations that are taking place now are judicial revocations, actions that are brought in federal court to revoke orders that have been entered.
Thank you.
Is there anything in the legislative history of the Act that would shed any light on this issue?
Unfortunately, there is not express legislative history that helps one way or the other.
No statement by the sponsor of the legislation saying we absolutely intend to take the power to denaturalize away from the courts and give it to the Attorney General?
No, there is not. We do submit that there is subsequent legislative activity that supports the position that the Attorney General has the authority to revoke orders of naturalization. Between the time that the regulations that are at issue were first published and the time they were finally adopted, Congress passed two major pieces of legislation in the area of immigration: the anti-death penalty and the Anti-Terrorism and Effective Death Penalty Act, EDPA. I'm so used to using the acronym, and IRERA, both of which were passed in 1996 before the regulations became final, but had been published, and Congress is presumed to be aware of the fact that they were published, and pursuant to those regulations, the INS would be able to conduct administrative revocation proceedings, and no provision was made in either of those statutes to say to the INA, to the Attorney General and the INS, you may not conduct this type of revocation proceeding. And subsequent to the final publication of the regs, Congress passed the NACARA statute, again a major piece of immigration legislation with no provision directing the Attorney General or expressly providing that the Attorney General does not have the authority to reopen or vacate orders of naturalization.
Were those enactments before or after Judge Rothstein's decision?
They were both before. They were both before.
Counsel, how much, in the government's position on this, how much reliance do you place on the idea that we should give Chevron deference to the agency's regulations?
Your Honor, I think that that it is very important to give deference to the regulations here. The plaintiffs have relied a great deal on the Minker decision, which dates from the mid-1950s, and from that have extracted a quotation that pertains to another provision of the law applicable in denaturalization proceedings, and there was, the court said that there was an ambiguity in the provision, the term witness. Did that include the subject of the denaturalization proceedings, or did it only include third persons? And the court there said, where there is an ambiguity, because of the importance of citizenship and the grave action of denaturalizing, that any ambiguity has to be resolved in favor of the naturalized person. But when Congress, when the Supreme Court passed Chevron versus NRDC in 1984, the Supreme Court said explicitly in that case that delegations of authority may be implicit as well as explicit, and where there is any ambiguity or where the statute is silent, that deference must be given to the executive in the administration of its own statute. And last term...
Well, 2 days ago, the Supreme Court handed down the Brown and Williamson case, which dealt with Chevron deference. And in that context, the Supreme Court also said that the agency's interpretation has to be consistent with the structure and theory of the law. And of course, in that case, it said the FDA's action was not consistent. As I understand the history of how denaturalization occurred, essentially it was always in a plenary proceeding, except in those rare occurrences where courts had summary proceedings based on not external evidence, but evidence that was internal to the application. Is there anything in the structure of the history of denaturalization that would indicate that a separate duplicate proceeding, adversary proceeding, would be initiated based on a collateral attack on the naturalization?
Well, I don't think it would be a duplicate proceeding, Your Honor. It's another way of proceeding rather than instituting a federal action. So it isn't really a duplicate proceeding. It's a way to reopen a proceeding and to vacate an order based on evidence of fraud or misrepresentation in the procurement of the proceeding. And when courts were acting pursuant to what was Section 340I, that was a way for a party on a motion to the court to have the order reopened.
Right, but I think in the Zuka, case which has been cited, and others, the Supreme Court seemed to cabin that authority in saying that the exclusive procedure for challenging a naturalization based on fraud had to be through the Section 348 procedure.
I know there is language to that effect in those decisions, Your Honor, but those decisions predate the change in the statute when the authority to naturalize resided solely in the courts. And so it would be only a court that would be considering vacating an order, and the question was whether it had to be done exclusively through under the provision at Section 340A, or whether it could be done as a reopening under the procedures applicable to reopening orders generally of a court. I'd just like to go back briefly to the question of Chevron deference and your question about the effect of the Brown and Williamson decision. I confess I have not read the entire decision, but the difference between the FDA proceedings and the administrative proceedings at issue in this case are the fact that these are administrative proceedings in the area of immigration. And last term, the Supreme Court in the Aguirre decision stated that, especially in the area of immigration, that substantial deference must be given to the Attorney General, particularly in interpretation of questions of law. And I think...
Counsel, help me on that proposition. You seem to be saying that Chevron overrules Minker. Minker says resolve ambiguity in favor of the citizen, and Chevron says resolve ambiguity by deferring to the administrative agency's interpretation, and you seem to be saying that Chevron overrules Minker. But usually when the Supreme Court has said two different things in two different cases, you don't treat the later one as overruling the earlier one unless it says that it's overruling the earlier one. Instead, you reconcile the cases. That's easy to do here because Minker is speaking very specifically of naturalization and denaturalization and focuses on the great stakes. They call denaturalization something that may result in the loss of both property and life, or of all that makes life worth living. That's not so with the general run of administrative interpretations. Why wouldn't it be right to just reconcile the cases, follow what the Supreme Court said in Minker, follow what the Supreme Court said in Binzik, where it said you can't infer the power to denaturalize from the power to naturalize, in the analogous circumstance there where power, as I recall, it was given to state judges, power to naturalize, and the Supreme Court said you can't infer power to denaturalize from that. Why not just follow Binzik, follow Minker, and distinguish Chevron? Because Minker and Chevron say different things.
Your Honor, I think that both Minker and Binzik were decided prior to this fundamental change in the way that naturalization orders were entered. And so I think to say follow them under the revised statute is not as simple as it sounds, because the statute is fundamentally different now in that orders are entered by the Attorney General rather than by courts in the first instance.
You then want us to limit Binzik and Minker as if those two Supreme Court decisions did not enunciate any general principles, but only construed the particular statutes as they were then.
Yes, Your Honor. I think that they do have to be limited in light of this fundamental change in the statute. And I do not take issue with what you said about the grave proceedings when...
I was just quoting the Supreme Court.
Counsel, you indicated earlier that there was no relevant legislative history with respect to the denaturalization issue. But step back a level, what was going on generally with the fundamental change? Could it be fairly supported that what was happening was there was an entire reallocation of responsibility from the courts to the Department of Justice and on to the INS, in which case whatever the courts could do before, now the INS can do? Or is that too broad a statement?
No, Your Honor, that is our position, that what the courts previously did has been transferred to the Attorney General, and that just as there was no express provision in the INA prior to 1990 that provided that courts could reopen or revoke orders of naturalization, that Congress, when it changed Section 310 and transferred the power to the Attorney General, along with the change in Section 340H, the Savings Clause, which says explicitly that nothing in this section shall be construed to limit the Attorney General's authority to, among other things, vacate orders of naturalization, we submit was done because Congress believed that there was inherent authority to reconsider, reopen orders that have been entered, and that the savings provision says that nothing in this Section 340 limits that authority to vacate an order of naturalization. I'd like to request if I could reserve the balance of my time.
All right, fine. That'll be fine, counsel. Yes.
May it please the Court, Jonathan Franklin, representing the appellee class. This is not an ordinary administrative area that we're dealing with here. As Judge Kleinfeld has pointed out, this case involves the fundamental right of citizenship, a right that the Supreme Court has said its importance and value cannot be exaggerated, one that involves serious repercussions in the denaturalization context, repercussions that the Court has said are more serious potentially than convictions for crimes. The Minker case governs here. In that case, the Court announced a clear statement rule that applies precisely to this context. The Court recognized the importance of the right of citizenship, the grave consequences of denaturalization, and accordingly, it announced the rule that where there is doubt is to be construed in the citizen's favor, and the presumptions of favoring judicial as opposed to administrative determinations on denaturalization proceedings applies unless Congress has given appropriately explicit instructions to the agency. The entire argument of the government in this case is that they have implicit authority. By definition, implicit authority is not an appropriately explicit grant of authority.
Counsel, have you had a chance to read the Brown and Williamson case?
Yes, I have, Your Honor.
How do you view its impact on the Chevron analysis in the context of citizenship as opposed to tobacco? Or I guess given that the Supreme Court stated, the majority opinion stated that the majority viewed the tobacco issue as an extraordinary case. I'm just wondering how the right of citizenship compares.
I believe the right of citizenship compares in the sense that it is more extraordinary in the circumstance of denaturalization to infer an implicit authority in an agency where it had never exercised that authority for the past 100 years. I think the last section of the Court's opinion in Brown and Williamson is particularly instructive here. It is in that section that the Court reviewed the history of tobacco regulation in the country and Congress's regulation of it, and concluded, based on the economic history, based on the history of regulation, that the Court would not infer a power to regulate tobacco. And the Court said at the end of its opinion, we are confident that Congress could not have intended to delegate a decision of such economic and political significance to an agency in so cryptic a fashion. Here, unlike in Brown and Williamson, there is not even a single word of statutory authority which the government claims can be interpreted to give it the power to denaturalize. The language they rely on is that the statute provides that the sole authority to naturalize citizens is conferred on the Attorney General.
What about the Savings Clause, which says nothing contained here in this section shall be regarded as limiting, denying, or restricting the power of the Attorney General to correct, reopen, alter, modify, or vacate an order naturalizing the person?
It is conceded in this case, and the government concedes it on page 16 and 17 of their brief, Judge Kleinfeld's dissent speaks of it, and I believe the panel majority also adopted the view that the Savings Clause does not grant any authority at all. All the savings clause does, it's a typical savings clause, it's the kind that legislatures enact all the time, and it preserves whatever authority might otherwise be out there and says that, well, if that authority otherwise exists, it's not affected by this provision. But there still must be a grant of authority, and the government recognizes that.
So your view of the savings clause in the context in which you read it is Congress was wasting its time to amend that section of the statute because it means nothing?
Not at all, Your Honor, not at all. The savings clause has substantial meaning. For example, the savings clause speaks of modifying, altering orders. There's no dispute here that the Attorney General would have the power to do that, provided that it doesn't affect the right of citizenship. Similarly,
It also says vacate.
exactly.
That would affect the right of citizenship, would it not?
Not necessarily, Your Honor. Section 342 is another statute which the government has really not acknowledged in this case. Section 342 says quite explicitly that the Attorney General has the power to cancel certificates of naturalization. And under the current scheme, a certificate of naturalization is the only order naturalizing a person. So Section 342 gives the Attorney General the power to cancel a certificate of naturalization. And this court has held recently in the Friend case that it gives the power to do so for any of the grounds, precisely the same grounds, that would subject a person to denaturalization under Section 340A. But importantly, Section 342 contains its own savings clause. And what Section 342 says is the Attorney General can revoke a certificate of naturalization, but the Attorney General cannot affect the citizenship status of the person involved.
I had a question about the relationship between the certificate of naturalization and the actual act of naturalization. I may be incorrect about this, but it seems to me that there are two steps. There's the certificate, and then there's the taking of the oath of allegiance. Are there two steps, or is that all in one?
My understanding is that the certificate comes after you take the oath of allegiance.
So I guess what is the role of the court in the naturalization process then? Because the statute provides, I think, that courts as well as the Attorney General can participate in giving the oath. And that's why I'm trying to parse out what that means.
There's a little history here. As well back into the 50s, the bulk of the naturalization process was undertaken by the Justice Department through an administrative procedure. It got to the point where pretty much the only thing that courts were doing in the naturalization process was giving the oaths and signing the orders. And so Congress in 1990 said, we're just going to recognize pretty much what's always been the case, and that is that the naturalization is done through the Attorney General. And what they did is they gave the Attorney General that last step of actually conferring the certificate. However, there remains an alternative procedure which a citizen can elect. It's an election by the citizen, can elect to have the oath given in a district court. And a lot of citizens like to do that because it's a formal process, and it's obviously a very important day for them, and so many of them elect to do it in court. So Your Honor is correct that the courts are not actually completely uninvolved in the current process. They do still give oaths. But the actual order naturalizing a person is the certificate of naturalization. So to get back to the Chief Judge's question about the Section 342 and the interplay of the Savings Clause, it's our position that Congress, when it enacted the Savings Clause, was merely preserving whatever authority might be out there. But it is, and that Congress didn't necessarily go and make a survey of exactly what statutes were there. But it is the case that every word in that statute does correspond to some authority that exists elsewhere. And I think on this point as well, the legislative history is important. I have gone back and looked at the legislative history of the 1990, and there is none, as counsel has conceded. And the reason there is none is that this amendment...
Was that a concession or just a statement of fact?
Excuse me, statement of fact, Your Honor. The reason there's no legislative history is because the amendments to Section 340H are basically buried in a section of the bill entitled Technical Corrections, where somebody just went through and struck out the word court put in Attorney General and interlineated struck out language that didn't seem to apply to the Attorney General.
But can we draw some significance from that? You heard my colloquy with Ms. Maher. It seems to me what may be going on here, and I'd be interested in your view, is that Congress was simply taking all of the powers over citizenship from the courts, transferring it essentially to the INS, and they purported to transfer the whole ball of wax. And why wouldn't they?
Well, they didn't transfer the whole ball of wax because Section 340A was not amended and remains intact today. And that's the section that says that for denaturalization, and I agree with Your Honor that the Congress was attempting to transfer naturalization to the Attorney General. That was the gist of the bill, and that's why, in fact, there is no discussion of denaturalization. Section 340A remained the same, still remains the same. And the Savings Clause itself does not grant any authority. One would have expected, if Congress had truly intended to make such a dramatic change in how people lose their fundamental right of citizenship, it would have done so expressly, it would have done so with debate, it would have done so with mention in the legislative history. And the Minker case is governing here. What the Minker case says is we are not going to imply such a dramatic power in the agency. The facts of the Minker case are very important here. The Minker case involved a person who, the government's attempt to serve an administrative subpoena on the target of a denaturalization proceeding so that they could take testimony from him prior to bringing a case in court. And what the Supreme Court said in that case is that we are not going to infer such a drastic power without a clear statement from Congress. Here, the case is even more dramatic.
Counsel, I'm not sure I understood your answer to the thrust of the Chief Judge's question, and I just want to clarify it. Prior to 1990, when did the Attorney General have the authority to vacate a certificate of naturalization without affecting citizenship? How does that work?
Section 342 gives that authority.
And but would you explain what the circumstances are?
Well, the circumstances, of course, that Section 342 applies to not only certificates of naturalization, but certificates of citizenship as well. And to take an example, this court recently decided in the Friend case, it's actually one of the few cases on Section 342, but what the court was faced with there was the revocation of a citizenship certificate, not a naturalization certificate.
Remind us of the difference between a certificate of citizenship versus a a certificate of naturalization?
Ordinarily, a certificate of citizenship is a recognition of citizenship that's conferred at birth. For example, if one's father is a citizen, under certain circumstances, you will be a citizen yourself, even if you're not born, or your parents are, you're not born in the country. And the Friend case was a case where somebody had said, I am a citizen by birth, and obtained a certificate saying that he was. Then the agency revoked that certificate, saying, no, under the law, you weren't. But the important thing is the Savings Clause of 342 involving affecting citizenship status didn't come into play in that case because the person had never been a citizen in the first place.
Right, but the question was related to the certificates of naturalization.
There's an old administrative opinion, and I think it's cited in the Friend case itself, where the government kind of went through this conundrum saying, well, we have the authority under Section 342 to take away a naturalization certificate where it's for the same grounds, basically, as we would denaturalize, but we're not going to exercise it because we can't affect the citizenship status, so we won't do it in that circumstance. Where it does come into play in naturalization certificates is a case where somebody's got a bogus certificate. It was never issued. It was somebody who got...
I'm wondering about another place. I recall this would occasionally come up in district court. The judge, at least when I was, would sign an order that had a long list of names. Ordinarily, there'd be one or two crossed out because they hadn't shown up for their interview or hadn't done something that was a prerequisite to getting naturalized. It seems inevitable that those of us who signed a lot of those with a lot of names on them must have signed some with wrong names on them. would that be the sort of certificate where now the INS signs the certificate with a long list of names, and every now and then it has a wrong name? The person actually never showed up, never took the oath, never got the interview, and that would be the one that they can take away the certificate?
I would distinguish two situations. I know the one Your Honor is referring to. I think if it was a situation where somebody had gotten the wrong middle name or something...
No, I wasn't talking about a misspelled name.
Right.
I was talking about the name was on the list because it was planned that that person would be ready to be naturalized at that ceremony. We used to have a big fancy ceremony. And actually, they weren't. They just hadn't gone through the steps.
Well, that's not this case, but I think the same principles apply in that situation, where a person has actually been naturalized, even though it may have been a mistake. The procedure is, the authorized procedure is to go to court under Section 340A and fix it that way. But there's a couple things to remember. First of all, in the current situation, the agency has ample time to locate and find those kinds of errors. For example, there is a lag, usually a substantial one of weeks or months, between the time when the agency internally grants an application of naturalization and when the actual naturalization is conferred. And they have a regulation, which is cited in the briefs, where they can revoke the grant of naturalization, of the application, prior to actually conferring citizenship on the person. So they have a check there that they can use. But once somebody has obtained citizenship, once somebody has their certificate saying you are a United States citizen, then, as the Supreme Court said in Berendi, the shoe is on the other foot. At that point, that's the point where the order is final. That's the point where the citizen receives substantial procedural protections before the government can go and take that citizenship away. In a case where it certainly was just a pure mistake, where the person had never shown up, a Section 340A proceeding presumably would not be very difficult to bring. It would be brought, it may be a consent judgment. The citizen may say, yeah, you're right, I wasn't there.
I was thinking that person never became a citizen because they never stood in court and raised their right hand and took the oath to renounce all allegiance to foreign princes and so forth.
Well,
you're not taking away the citizenship.
I think that's a difficult case in that circumstance, but I think one could also argue that the person did become a citizen because they got their certificate. Of course, in the certificate is the order of naturalization. It is the evidence. It is the conferral of citizenship on you. And it may be that for any number of reasons, the person wasn't qualified, as it turned out, to obtain citizenship, and that person can be denaturalized, whether it's because they didn't take the oath, which may be just a technical matter, or whether it's a more serious matter. But in any event, the authorized procedure, the one that Congress has set forth, is Section 340A. That's the one that requires to go to court. The agency, all agencies are creatures of Congress, and they can only act as Congress has directed them to act. In this case, we have not a single word of a statute that's even ambiguous in conferring the naturalization authority on the Attorney General. The Savings Clause, it's conceded, does not confer anything. It merely saves.
Well, on that point, counsel, I guess the government's really making two slightly different arguments. One is that the Savings Clause transferred the residual power of courts to denaturalize in procedures other than 340. And the second argument is that administrative agencies have the inherent authority to correct any order that has nothing to do with that. Let's take the first one. Do you think, assuming that the intent was to transfer the summary power of courts as opposed to the plenary power of courts, what was that power?
It's not clear, Your Honor. There was a split in the courts on that precise issue prior to 1990. Many courts refused to exercise what Your Honor's referred to as a summary power, where there was no reason why the government could not proceed under 340A. This court, in the Magnuson case, albeit in dicta, firmly aligned itself with the line of authority that said that it would be an affront to the principles of citizenship to allow the government to exercise denaturalization authority in a summary fashion. So the answer to your question is it's not clear. There were some courts that exercised it. There were some courts that didn't. But all this points, I think, clearly to the fact that Congress in 1990, through no explicit language, could not have intended to grant the kind of drastic authority, the kind of authority that unprecedented authority that the Attorney General is exercising here. The Minker case applies. If Congress wants to do that, subject to the requirements of due process, I think it is free to do that.
Is there a case, going back to the summary authority of courts pre-1990, is there a case in which a court exercised its summary authority by shifting the burden of proof to the applicant?
Never, Your Honor, never.
And that's different with the INS procedure now.
Certainly, and that's another reason why these procedures, we believe, lack statutory authority. The government is saying, I mean, they have regulations that they've adopted, but those don't embody the sum total of what they say they can do. And the regulations themselves don't provide for an independent hearing, shift the burden of proof, allow the decision maker to be the same one that instituted the proceeding, and expand the time limit from 1 to 2 years. So to imply the kind of authority that they have usurped for themselves is, I think, a drastic step, and one that should be done by Congress, not by this court.
I gather the district court didn't quite agree with your analysis, because as I understand what the district court said is that authority was transferred, but it was conditioned or limited by the same authority that the courts had under 60B. Do you disagree with the district court's analysis?
I think what the district, first of all, it was a preliminary injunction proceeding at the time, but I think the district court, what the district court held was that the power was at most limited to the power that the courts exercised. I think that on the preliminary injunction proceeding the court had before it, I don't think the court felt it needed to answer the broader case, but I don't think the court disagreed with our principle. It just relied on different factors. I think that the difference between the Attorney General's regulations and the prior proceedings in courts is relevant here and is an important factor to be considered in determining whether or not Congress intended this, because that's ultimately what we're talking about here, is what did Congress intend?
Mr. Franklin, following up on that and on Judge Thomas's question, what is your response to the government's position is because of those circumstances, this is an appropriate case to apply Chevron?
My response, well, I think Chevron appears at maybe one place in their brief, and I don't think Chevron is appropriate here for the simple reason that there's no ambiguous statutory language that's being interpreted here. The language is clear. The Attorney General shall have the authority, the sole authority, to naturalize.
Well, what is the meaning of the savings clause? There's nothing to be saved?
No, the meaning of the savings clause is whatever power is out there is saved, and I've enumerated several instances.
Doesn't that make it ambiguous?
No, the savings clause, one thing we know about the savings clause, and that's been conceded in this case, is that it doesn't confer power. So it's not a question of looking at the savings clause and trying to figure out if it confers power. Indeed, if the savings clause conferred the power, then it wouldn't be a savings clause at all.
No, but I think everybody agrees, so it applies to whatever's out there, but there is a dispute as to what's out there. Isn't that the appropriate place to apply Chevron?
If there's a statute out there, that is...
Or inherent power out there.
Well, I don't think Chevron applies to inherent power. I think Chevron applies where the agency is interpreting some ambiguous statutory language. But I think Minker here is the governing case. Minker said, in the context of a statute that said the Immigration Service has the power to subpoena witnesses, we are not going to interpret the word witness to include the target of the denaturalization proceeding because of the security of judicial over administrative denaturalization and the presumption that those are going to be decided in court. Here, in that case, what the service was attempting to do was to take a portion of the denaturalization proceeding, the evidentiary portion, to itself by subpoenaing a witness so that they could give testimony in private before an immigration officer. And the court said, no, you can't do that without an appropriately explicit grant from Congress. Here, they've gone even further. It's not just the evidentiary portion that they've taken unto themselves, it's the entire proceeding.
What is the documentary evidence of an order of naturalization?
The certificate. Now, it used to be a court order.
So when the savings clause says that the Attorney General has the power to vacate an order of naturalization, wouldn't that be vacating the certificate?
Correct. And under section, if the court needs to look for something that corresponds to every word, section 342 does give the power to vacate a certificate. But what it expressly says is that power does not include the power to affect citizenship status itself. And here what the government is doing is they're doing the first step. The regulations at 8 CFR 340.1 subsection G say that under this procedure, the certificate will be vacated. So that's part of the procedure. Then they're taking the next step. They're saying, we're also going to say you're not a citizen anymore. And that's the step that's expressly prohibited by section 342. This is not a case where as in other contexts, one might need to look for an implied authority because there's no express authority anywhere else. There is express authority here, section 340A, and that provides that you go to court. There's also an express prohibition in section 342, which says this far the Attorney General can go, but no further. And I think that the statutes here are clear, so there's no need to look for ambiguous language or apply deference. Minker says, in addition, that the Congress has to give appropriately explicit instruction. It has not done so here.
How do you respond to the government's argument that each administrative agency has the inherent authority to revisit its own orders?
I don't think that principle, if it indeed exists, can be divorced from the context, specific context that we're dealing with here.
Well, let's assume that I know these regulations deal with fraud and so forth, but let's say that we have a technical error such as the ones described by Judge Kleinfeld. Do you think that the Attorney General would have the authority to reopen and correct those?
If it did not affect citizenship status, yes. I think in that instance, the Attorney General would be exercising part of the naturalization power, the power to confer citizenship and make sure the name is right and things like that. But if it's a case where it results in taking away something that's already been granted, no, the Attorney General would not have the authority to do that.
Would you say that the Attorney General had the authority to alter her decision prior to the time that naturalization became final?
Absolutely, Your Honor, and I think it's up to the agency, and I outlined the procedure that the agency uses and has used and used before 1990 to do that. There's a time lag between the time when they stamp the application as granted and the time when the citizenship is actually conferred, when the oath and the certificate, the formal time at which, and during that time, the order is not final, and it can be revised and it can be revoked, and there's a procedure for doing that, not being challenged in this case. Every class member in this case was an American citizen, is an American citizen today, subject to a final order of naturalization. The Supreme Court has held that citizenship is a fundamental right and that denaturalization imposes severe consequences on the person. In recognition of that fact, Congress has established an express judicial denaturalization procedure and has prohibited the Attorney General from exercising that same power. The American citizen must have the security of knowing that once his precious right of citizenship is obtained, it will not be taken away except as Congress has authorized. The regulations now before the court, in our view, show the little regard the INS will accord to the fundamental right of citizenship if left to their own devices without any statutory authorization. That is why the court should enforce Congress's intent, hold that the regulations lack statutory authority, and affirm the judgment below. It will not prevent the government from proceeding under Section 340A, but it will prevent the government from proceeding in a manner that Congress has not authorized. There are no further questions.
All right, thank you, counsel.
I'd like to address the suggestion by Mr. Franklin that Section 342 of the Act constitutes or includes a prohibition on the Attorney General revoking an order of naturalization. Section 342 is the provision that relates to cancellation of certificates, and certificates are different from the orders of naturalization.
I was a little surprised by something counsel said, and I don't know how this procedure works anymore. It used to be there was an order that the judge would sign with maybe 35 names on it, one or two crossed out, the ones that didn't show up for one or another step. And as I understand it now, the judge no longer signs an order with 35 names on it. Nobody signs an order with 35 names on it or one name on it. All that happens is the certificate. The old way was the judge signed the order and the INS gave everybody an individual certificate. But now they're nothing but the certificate. Is that true?
No, there is an order of naturalization, but that is the order of naturalization is the act pursuant to which a person becomes naturalized.
Is there a signed paper that says order on it?
From the INS?
Yes.
Other than the certificate?
That's what I'm asking you. I want to know, are there two papers like there used to be, an order and a certificate, or is there one paper?
There is an approval. I don't know whether it specifically says on the document that it's an order, but that is the order of naturalization, approving the application of the person to be naturalized.
What paper is that on?
Is it on? I'm not sure what it's specifically called. It probably has a numerical designation, but I could find that out and advise the court.
Counsel, would you respond to Mr. Franklin's point when I asked him about Congress was really trying to just move everything from the courts to the INS? He said, well, not entirely, because 340A is still there. What's your response?
340A still is there, and there are other means for proceeding in court to denaturalize. There still is the possibility of criminal prosecution for obtaining naturalization illegally. And the provision is Section 340E references criminal prosecution for fraudulently obtaining an order of naturalization. But that section, as other sections, refer to both orders and certificates. So there is still a role for the courts, and certainly after the 2-year period that would be applicable for reopening by the INS of an order of naturalization, an action can be brought in court to vacate an order of naturalization.
We've been concerned about the savings clause not having anything to save. Does 340A have any content? Why would the agency ever go to court if it can take care of it itself internally?
Well, first of all, it would have to go to court if, under the regulations as they're now written, it can reopen administratively only within 2 years after the order of naturalization is entered. So it would go after that 2-year period. But 340A existed when courts had the authority to reopen, vacate orders of naturalization during that 1-year period under Rule 60B. I just wanted to emphasize the point that Section 342 does not contain a prohibition on the Attorney General reopening or vacating an order of naturalization. What it says is that the Attorney General may not do it under this section. The cancellation under this section of a certificate does not affect the underlying order. Section 342 is a provision that relates to document fraud and authorizes the Attorney General to take action to cancel certificates of citizenship. 342 predates the 1990 amendments and was not changed at the time the 1990 amendments were made to the statute. And so, given that it existed at a time when the Attorney General could not take any action to effect an order of naturalization, it makes sense that the provision says expressly that any action that the Attorney General takes pursuant to Section 342 to cancel a certificate, the paper that says I'm a citizen, doesn't in any way affect the underlying citizenship status of the person in whose name that certificate was issued, whether that person is a United States citizen or a citizen of some other country. There is no express prohibition in Section 342 as counsel for the plaintiffs would argue.
I'm still uncertain as to what specifically is the order of naturalization that can be vacated. We've talked about it being the certificate. We've talked about it being some sort of separate piece of paper. What is it?
It is not the certificate. It is the grant of naturalization. When an individual applies, goes through the procedures, is interviewed, and is ultimately approved, it is the grant of citizenship status.
In what document does that occur?
And I don't know how to describe it other than sort of circularly to say that it is the order, it is the approval that is issued to the applicant.
Well, is there actually a separate document that does that, like Judge Kleinfeld was asking?
Yes.
There used to be one.
Yes, you could have an order but never obtain a certificate which says that, you know, separately, I am a citizen of the United States. Similarly, someone could have a fraudulently procured certificate issued in his or her name and not be a naturalized citizen.
Let's see. I'm not sure that I'm understanding. Is this a situation where the Attorney General, through the INS, issues a document that says order of naturalization?
Yes.
Counsel, I
To
think
an approved applicant.
Sorry, I think Chief Judge Hugg is asking a very critical question, because it goes to the meaning of the savings clause, if any, and I'm not sure that it's been bandied around that there's a concession on that, but it's still a question of law. And I sense some questioning about what does that savings clause mean. And it refers to an order. And I think both Judge Kleinfeld and Chief Judge Hugg are saying, or questioning you, is there an order that puts some context on that savings clause? And you've answered it a couple different ways. I can tell you from my own experience, having naturalized citizens as a district court judge since 1990, I don't recall an order, an actual document that said order. And I guess that's a really important question, if the savings clause has any meaning. Is there such a document?
But since after 1990, it would be something that would be issued by the INS rather than the court. The court would not issue the order of naturalization.
Right, but does the INS issue an order?
There's not something...
Is there something written that is a grant or an approval? Your request to become a citizen is hereby approved. So there's this piece of paper, then the person has to do something else. This is sort of related to my earlier question. The person takes that piece of paper and converts it into a certificate of naturalization by taking the oath of allegiance.
Yes.
Okay, so there really are two pieces of paper, even though one doesn't say the word order at the top. It's an approval of the application to become a citizen.
That's correct.
And then there's another step, which may be done by a court or by someone else, and then the certificate occurs. So to get back to the subject under discussion, does the term order in subsection H pertain to the pre-certificate things
approval,
or pieces of paper?
Yes. That the order refers to the approval of the application.
That's a little different from the old order. If all there is, in the old system, there were the two things. I hereby order as a United States District Judge that John Doe is naturalized as a citizen of the United States, and also a certificate. And the INS could revoke the certificate but not the citizenship. That would leave the order standing. If the INS does not issue a piece of paper saying it is hereby ordered by the INS that John Doe is a citizen of the United States, if the only thing that says that is the certificate, then we already know that the INS's power to take back the certificate, to vacate the certificate, is limited to the certificate itself and not the person's citizenship, because the statute says so expressly.
In Section 342?
Right. Maybe you could identify a regulation that says what order shall issue. Do you happen to recall?
I don't think it is defined in a regulation. But Your Honor, just to clarify, or to try to clarify, the situation is that there is an approval of an application.
That sounds
which
like
is
congratulations, your application is approved. If you appear at such and such a date and take your oath, then you will become a citizen.
And
That's
you
not
may be
like the
issued a
old-
certificate.
But that's not like the old order that said you are a citizen. It's just an invitation to go through the next step to become one. And it leaves nothing conferring citizenship except the certificate. And we already know that the INS's power over citizenship, insofar as it relates to vacating the certificate, is restricted by Congress.
The reason it is different, Your Honor, now is because there is not that next step. It's not required for the approved applicant to then go to court to have the court enter the order of naturalization.
All right, thank you, counsel. The case just heard will be submitted, and the court will be in adjournment.
Hear ye, all persons having had business with the Honorable United States Court of Appeals for the Ninth Circuit will now depart for this court. This session now stands adjourned.
You're watching a special edition of America and the Courts, featuring oral arguments before the 9th U.S. Circuit Court of Appeals. Each takes place before en banc panels of the court. The panels consist of 11